Sources are a big part of the work that we do as journalists, and the court has weighed in on some of the aspects of the relationship that we have with our sources. So let's take a look at those. One of the questions that we often have is working with anonymous sources. So we have a sensitive story. There's people who do not want their name attached to information. It presents a lot of challenges, as I'm sure you can guess. We have difficulty if we can't tell the public who's providing us with the information. There's a level of trust that we're compromising. So we really do try to use it as a last resort. It can be something that sources will hide behind and maybe not give us completely accurate information. So although they are incredibly useful to us when they do provide us with the information we need, and for various reasons cannot release their information, we do have to be very careful. So legal protection provided to journalists to keep sources as confidential is not 100%. We really don't have the authority in some ways to tell someone that we're not going to release their name or information. In some cases, courts can compel journalists to reveal information even when they've promised confidentiality. So let's take a look at those cases. The first one is Branzburg v. Hayes. This is a pretty prominent case in journalism law. Branzburg wrote a story about people who were synthesizing drugs in Kentucky. He was called before state grand juries, and he refused to disclose the identity of his confidential sources. This case was actually conjoined before it got all the way to the Supreme Court. With two others, one in re Pappas and United States versus Caldwell. These were both cases of two other reporters, each recovering activities within the Black Panther organization, and they were also called to testify before grand juries and reveal where they got their information, and they refused to do so. So the question that the court was asking was, is this requirement that reporters appear and testify an abridgment of the freedom of the press and free speech guaranteed by the First Amendment? And they actually said no in this case. So requiring reporters to disclose this information, especially to a grand jury, serves that compelling and paramount state interest that we've heard about before. This is not a case of prior restraint. This is a case where the information has already been obtained and published, and so the fact that the reporters get that information from a source in confidence doesn't privilege them to withhold that information during a government investigation. Now, the aftermath of this, as I'm sure you can guess, was substantial, and the Society for Professional Journalists is still trying to get legislation through to protect confidentiality of sources, but we haven't made much headway there. Now, another case a little bit more recently was this Cohen versus Cows Media, where Cohen was a campaign associate in a Minnesota gubernatorial race. He gave court records to the St. Paul Pioneer Press and the Minneapolis Star-Tribune with the promise of confidentiality. Now, ultimately, the papers ended up identifying Cohen, and he was fired. He ended up suing the paper in state court, alleging breach of contract. And the question was, did the First Amendment bar a plaintiff from recovering damages for a newspaper's breach of confidentiality? And it didn't. In this case, what we had was the idea of promissory estoppel, and that is that a promise had been made from one party to the next, and that promise had been broken. And because of that, now we had a situation where the journalist could be punished because of that. Now, in this case of Ventura versus Cincinnati Enquirer, we have the case of George Ventura, who was actually legal counsel to Chiquita Bananas, the company that imported those, and he ended up providing information to a reporter for the Enquirer that allowed this reporter to access the phone records of the company, and the reporter basically stole voicemail messages. So when he was identified, when Ventura was identified, he sued the Enquirer for breach of contract. And he said that the fact that the reporter had identified him as the confidential source was that the newspaper should be responsible for that. Now, this got to the Sixth Circuit, which is the high appellate court that covers the Ohio area, and they said the Cincinnati Enquirer was not liable for this. There's no way that they could prevent a former reporter from identifying a confidential source to a grand jury investigating the criminal activities of both the source and the reporter.